So the first witness is a representative from the Department of Justice, Vijay Shankar. Mr. Shankar currently serves as Deputy Chief of the Appellate Section in the United States Department of Justice, where he worked since April 2005. Before then, he practiced law in D.C. in the areas of white-collar criminal defense, complex civil litigation, and appellate litigation. So you've seen both sides of this.
Yes.
Mr. Shankar is joined by Marianne Mariano for the Federal Defenders. Everyone knows her, so I need not go on. And then Dr. Virginia Swisher is testifying on behalf of the Commission's Victims Advisory Group. Dr. Swisher is the founder, director, and CEO of Problem Solving Consultants, a conflict resolution consulting service. Dr. Swisher previously worked for 20 years as a federal probation officer. Where?
District of Connecticut.
District of, oh, a New Englander. So why don't we get going with you? You were champing at the bit, come out of the box.
That's right. Judge Saris and members of the Commission, thank you for the opportunity to share the views of the Department of Justice on the Commission's proposed amendments to the sentencing guidelines regarding conditions of probation and supervised release, sections 5B 1.3 and 5D 1.3. I am Vijay Shankar. I'm Deputy Chief of the Criminal Division's Appellate Section. I have represented the Department in dozens of criminal cases involving probation or supervised release, and I recognize the importance of the issues the Commission is addressing. The Department appreciates the Commission's efforts to revise and clarify the conditions of supervised release and probation. As a general matter, the Department is in favor of the Commission's desire to resolve ambiguities and simplify the guidelines, and we think the proposed amendments include a number of improvements. We do, however, have several concerns which are addressed more fully in our written submission, and I will speak to just a few of those today. First, the Department recommends that the proposed fourth standard condition of both probation and supervised release should read as follows. Quote, the defendant must answer truthfully all questions asked by the probation officer, unquote. The current condition states that a defendant shall answer truthfully all inquiries by the probation officer. The Department believes that the proposed deletion of the word all could be read as a substantive reduction in the defendant's obligations and is unwarranted. In addition, in response to the Commission's solicitation of comment, the Department's view is that there is no basis for altering the condition to require the defendant only to, quote unquote, be truthful when responding to questions by the probation officer, nor is there a basis for including a proviso that an offender can evoke his Fifth Amendment privilege against self-incrimination in response to a probation officer's question. First, as the Supreme Court has recognized, imposing a general obligation to respond truthfully to a supervision officer's questions does not conflict with the right against compelled self-incrimination. Second, there is no requirement that a probationer be affirmatively advised of his or her Fifth Amendment right against self-incrimination. So long as a condition of probation merely requires a probationer to appear and answer truthfully, rather than requiring the probationer to choose between making an incriminating statement and jeopardizing his or her conditional liberty by remaining silent, there is no Fifth Amendment concern. Restricting this condition or interjecting Miranda-like cautions about self-incrimination into the supervision context, where there is no legal basis for doing so, could curtail questioning of or responses by supervisees regarding offenses they may have committed to the detriment of both supervision interests and law enforcement interests. Second, the Department recommends that the conditions requiring defendants to refrain from excessive use of alcohol and to support dependents and meet other family responsibilities be retained as standard conditions. Excessive alcohol use contributes to criminal behavior, hinders rehabilitation, and conflicts with other conditions of supervision, including those relating to employment and family support obligations. Vagueness concerns can be addressed by making the language more specific, and indeed the Department suggests that the condition be rewritten to say that the defendant must follow any instructions of the probation officer to limit or refrain from the use of alcohol. This would enable probation officers to assess whether the extent of alcohol use by their supervisees is interfering with their rehabilitation or compliance with other supervision conditions, and to issue remedial instructions. Similarly, we suggest that the standard condition relating to family responsibilities be rewritten as follows. The defendant must meet any legal obligation to support or make payment toward the support of any person, and must follow any instructions of the probation officer with respect to meeting other family responsibilities. In the Department's view, the special condition proposed by the Commission is too limited and fails to account for the fact that meeting the full range of legal and social obligations to one's children, spouse, and parents is conducive to rehabilitation and should be promoted as an aspect of supervision. Finally, the mandatory condition concerning compliance with the Sex Offender Registration and Notification Act, or SORNA, is inconsistent with applicable law. As currently drafted in the guidelines, the condition assumes that there are some states in which SORNA does not apply. For those states, it improvises a non-SORNA set of registration requirements for sex offenders based on provisions of older laws that SORNA repealed. SORNA, however, is a federal law, and its requirements apply to sex offenders in all states, regardless of whether the state has implemented SORNA's requirements in its registration program. The condition would correctly reflect the law if formulated to track the corresponding statutory language as follows. If the defendant is required to register under the Sex Offender Registration and Notification Act, the defendant shall comply with the requirements of that act. In closing, I would again thank the Commission for this opportunity to share the views and concerns of the Department of Justice. The Commission's efforts to clarify the supervision conditions guidelines are commendable, and the Department looks forward to working with the Commission on this important issue. Thank you.
Thank you.
Good afternoon. The federal public and community defenders appreciate the Commission's decision to review the conditions of supervision and your interest in making the conditions easier for our clients to understand. However, we question the necessity of many of the standard conditions as standard conditions instead of special conditions, and we are concerned about the overbreadth and ambiguity of some of the proposed language. For too long, the focus of sentencing has been on how long a person's prison sentence should be, and too little focus on other aspects of the sentence, including supervision. Supervised release primary purpose is to facilitate reintegration of a defendant into the community, thereby reducing the chances of recidivism and protecting the public. But the long list of blanket conditions does not serve that purpose. As a threshold matter, we believe the Commission should reduce and limit the number of standard conditions, making most special conditions, for several reasons. First, this slate of conditions undermines the statutory requirement that the court make specific findings when imposing additional conditions of supervised release, including the requirement that any condition be reasonably related to a specific 3553A factor, and that it involve no greater deprivation of liberty than is reasonably necessary to serve that purpose. The standard conditions do not require such findings and ignore the need for consideration of the history and characteristics of the defendant. For example, the proposed standard condition regarding the notification of third-party risk to another person or organization should be a special condition. Not only is the condition not applicable in every case, it is also not sufficiently narrow because it fails to specify the nature of the offense or characteristics of the defendant that pose the risk, facts that must be tailored by the court to the specific defendant. Moreover, one-size-fits-all conditions are not compatible with the approach to supervision that the U.S. probation system has been trying to implement. According to the evidence-based practices of probation and pretrial services, conditions of supervision should be directed toward a particular criminogenic need. If conditions of supervision are to be consistent with that approach, there should be few standard conditions and more special, specifically targeted to the needs and responsivity of the individual defendant. For example, the travel restriction. If a defendant resides near the border of a federal judicial district, it may be appropriate for him to routinely leave the current district to facilitate employment, healthcare needs, or reintegration with family. The condition of, that he may not knowingly leave the federal judicial district without permission is not appropriate as a standard condition, but must be tailored to the defendant and possibly the district's specific circumstances. And I believe it often is. Studies have shown that extensive standard conditions of supervision may be unnecessarily burdensome. Rather than help reintegrate a person into the community, too many conditions can set him or her up for failure. Defenders' experience shows that technical violations leading to revocations, even where there's no evidence of criminal activity and where the defendant might otherwise succeed at reintegration. One example is the condition regarding full-time employment. For some of our clients, this is simply unattainable, possibly because they are elderly when they're released, or they are infirm or physically or mentally infirm, after they've served a lengthy prison sentence. The same is true of a GED condition that seems completely appropriate not only to the court but maybe the parties involved when imposed on a 20-something-year-old defendant, but who isn't going to be released until he's in his 40s. For these reasons, we urge the condition to limit the number of standard conditions, making many of them special conditions to be imposed by a court on a case-by-case, defendant-by-defendant basis. Defenders will rely on our written testimony regarding our concerns as to specific conditions. However, I'll briefly address the one condition that was highlighted in the Commission's issue for comment, specifically the condition that a defendant shall answer truthfully the inquiries of a probation officer. We appreciate the Commission's interest in the supervisee's Fifth Amendment concerns against self-incrimination, which is not sufficiently protected under the current language. Under the current language, a supervisee may be placed in the position of having to choose between answering the question truthfully and incriminating himself, or not answering and face a revocation. However, we do not believe the language proposed by the Commission, either option, is sufficiently clear and does not adequately convey to the average supervisee that he or she need not answer every inquiry posed by the probation officer. Accordingly, we've proposed the language that has been read by Commissioner Barkow in to the previous panel. It is our position that this straightforward language will make clear both the obligations and the rights of the supervisee. And we applaud the Criminal Law Committee's position that invoking your Fifth Amendment right would not be grounds for a revocation. Thank you.
Thank you. Dr. Swisher.
Judge Saris, if I could update my credentials since my bio information was submitted. I was recently appointed as a lead faculty area chair for the College of Security and Criminal Justice for the University of Phoenix at the Tempe, Arizona campus, so it really is good morning still for me, but good afternoon.
You moved to that beautiful climate there, huh?
And I'm loving watching winter from Arizona. Thank you, Judge. I would like to thank you and all of the commissioners for the opportunity to represent the Victims Advisory Group at this important hearing. At this time, I would like to focus or take a few minutes to reiterate our comments that were put into our written testimony concerning the proposed amendment on third-party risk. In the current conditions at sections 5B 1.3c and 5D 1.3c, third-party notification shall be made either by the defendant as instructed by the probation officer or the probation officer if risks are posed by the defendant's criminal history, personal history, or characteristics. Under the proposed amendment, the language of the standard conditions at both sections would be modified from a shall to a may, while removing the probation officer's ability to make independent notification of the defendant. As currently presented, the proposed amendment states that if a probation officer makes a determination that a defendant under supervision poses a risk to another person or an organization, the defendant may be required to notify that person of the risk. The proposed amendment does not or does clearly state that if the defendant is instructed to make notification, that he must or she must comply with that instruction. It is the position of the Victims Advisory Group that removing the emphasis inherent in the word shall and eliminating the probation officer's ability to make independent notifications may create a situation where individuals or the community are put at risk. If a risk has been determined, the probation officer is not required to ensure a third-party notification is made, as would be the case with the language such as shall make notification, but rather the probation officer may require the defendant to make the notification. Follow-up by the probation officer may or may not occur. As stated in the proposed amendment, the probation officer may contact individuals and confirm that notification has been given. If the probation officer confirms that the defendant has not made notification, the proposed amendment does not clearly permit the probation officer to make that notification. The current condition is enforced in those situations where a defendant clearly victimized members of the community in the commission of the offense of conviction. I note that a third-party notification is not required in all instances, and implementation of the current guideline can vary from circuit to circuit. For example, there are differences in the way the current guideline is implemented in the Second Circuit and the way it is implemented by districts in the Ninth Circuit. If the proposed amendment is adopted, the variation has the potential for increasing the chances that the community is at risk of future victimization by defendants on supervision. Maintaining the third-party risk condition in its current mode will provide the sentencing court with a valuable tool to try to prevent any further victimization of the community by a defendant for as long as supervision continues. Retaining the current language may also help inform the general public and reinforce a sense of confidence within the community that the court truly does take the protection of the community very seriously, a message that may also resonate with the defendant and perhaps enhance the deterrence goal of sentencing. Judge Saris and Commissioners, thank you for considering my comments on behalf of the Victims Advisory Group.
Mr. Shanker, let me turn to the DOJ's position with respect to whether an individual can be required to answer truthfully, especially in cases in which he or she may be incriminating themselves. The Ninth Circuit says you don't. Ninth Circuit, which a number of us have to follow, the law is different from your stated policy. So how do you deal with that? If, in fact, a person retains his or her Fifth Amendment privilege, it is not a basis for revocation of probation that that person failed to respond to a question. How do you deal with that?
Your Honor, we agree that a probationer, a supervisee retains a Fifth Amendment right not to answer a question that would put them between the option of answering and incriminating themselves or being punished. And so we don't disagree with that. The question is, do they have to be affirmatively advised of that fact?
Okay, that's what I didn't understand. In other words, the part that you're objecting to is the duty of the probation officer to advise a person that he or she need not answer.
Correct.
Questions on a Fifth Amendment privilege.
Correct. Now, I will
you're not
say
quarreling with the exercise of the privilege. You're
No, absolutely not. If a probationer invokes his or her Fifth Amendment right in response to a question, as I think Judge Martinez said, that could be taken to a court to determine whether the invocation is appropriate or not.
I think I misunderstood your comment and your
Certainly.
clarification.
I will add, though, not to belabor the point, though, that the mere fact of being required to appear and answer a probation officer's questions does not, in and of itself, put the Fifth Amendment choice to the defendant. It's being asked a question that might or might not incriminate.
I think that's right. And I think if it were otherwise, you would defeat a lot of the purpose of supervised release, which is to try to give some guidance to the people and to protect victims on an ongoing basis.
Exactly.
Thanks. Thank you for your answer.
I suppose one of the debates is how much power should be in the probation officer versus the court. So I know in the area of drug testing in our circuit, the court decides how frequent the drug testing is, not the probation officer. So you're suggesting in the area of excess alcohol that it should be the probation officer making the call as to what's excessive? Is that your proposal?
Well, I think that the proposal would be that the probationer must follow the probation officer's instructions with respect to refraining from or limiting alcohol use. So at some level, we are relying on the judgment, the discretion, and the experience and expertise of the probation officers, and I think that's what the conditions are founded on. The whole principle behind conditions of supervised release are founded on those principles, judgment and discretion of the probation officer. The courts are overburdened. We don't want to involve the courts in all of those questions. I think the reason that the department has proposed phrasing this in terms of an instruction by the probation officer is in part to eliminate the vagueness concern that courts have raised about the blanket use of the word excessive use.
Can I ask, other than the Seventh Circuit, I come back to, sort of at some point, I've been a judge a long time, and the issue has never come up. So I'm trying to just figure out how widespread an issue this is for both of you who see the nation as a whole, whether people are litigating how much is excessive alcohol, or how much is too much child support, or how much is overuse of the risk notification. I get it that sometimes maybe these are overused and Seventh Circuit is worried about it, but is this a national problem that you've seen?
Your Honor, from our perspective in criminal appellate, we have seen the vast majority, if not all, of these decisions coming from this one court, the Seventh Circuit.
But then maybe you can answer it this way, because I think the battle that we have, not battle, that glorifies it. The discussion that we're going to have is what should be standard, what should be special. And we understand, at least I understand when you say these conditions ought to be standard in terms of desirability. That is, if I were running a Sunday school, I'd like to have the person pay for his obligations for support. I'd like the person not to drink excessively. I'd like this, I'd like that, I'd like that. So if I could put a big list of standard conditions out there in terms of desirable conduct, ways to avoid criminal conduct. But if you accept the logic of the Seventh Circuit, if you accept their logic, they're saying all of these conditions should be looked at in terms of the individual probationer and the problem that individual probationer has demonstrated. Ninth Circuit is saying basically the same thing. What has that person demonstrated to the court? And so what's wrong? Maybe I could ask it this way. What's wrong if we take this collection of desirable conduct and put it into special conditions where that defendant seems to have a lacking? Is anything harmed?
And the court looks at it.
And the court looks at it. Is there anything harmed by that? I mean, let me tell you, all you have to do is sit and listen to these judges' sentence. It's mind-numbing. It is mind-numbing, and I know they don't hear half the things that we say. And the judges' modus operandi is to get through it as quickly as possible because they have so many of these conditions. And I guess my question is, what law enforcement purpose is hindered, not furthered, by putting these things as special conditions rather than general conditions?
I think the primary risk with that approach is that the conditions can be excluded inadvertently or otherwise. And in addition, the concerns that may be placed in special conditions might arise later on and might not be in place when the defendant is
We do have a vehicle for that.
There is, but that, again, takes up court's time. And if we put these in as standard conditions, and they may not apply in 100% of the cases, they may not apply to that defendant at all, the probation officer has the discretion and the judgment to basically ignore that condition with respect to that particular defendant. I guess, with due respect, not to flip the question,
that all the time.
but yes.
I know, right when someone says that, they're about to.
To flip the question, I guess the question is, what harm is there in having these as standard conditions if, when in cases where they don't apply, the probation officer doesn't have to
Well, there is some harm in making pronouncements that are irrelevant to the particular
Well, so
case.
then I would go back to Judge Sarris's question, which is that we really are not seeing, as much as the Seventh Circuit has suggested with a long list of hypotheticals, we are not seeing these problems. We are not seeing a lot of revocations on this. The Commission's own study has found. So, and I don't want to monopolize my.
Do you see a lot of these issues being debated in the context of sentencing? Maybe they come up in revocations.
So they do come up in revocations, but I would say this, that I do think it is a national problem within which maybe we've all been complicit. My federal defender colleagues in the Seventh have led the charge in these cases, and I frankly applaud them for it. I have litigated these issues. I litigated a case called Peterson, which we cite in our papers. That client got probation, so of course his conditions were front and center, and I was successful for him on appeal, one of which was the risk assessment that wasn't tailored specifically to him, among other conditions.
Risk of
Third-party notification, sorry. I think I said risk assessment, which is an entirely other thing. I apologize. I also say, what is the harm? in setting the standard conditions that actually apply to a specific defendant at the outset, and to allow probation to come back, standard and special. Let me qualify. Of course, there's special conditions in almost every one of our cases. In my district, we actually get written notice in the PSR of the special conditions, and so those often do get litigated at sentencing. But the standard conditions, this blanket 14 condition list, I feel has been largely ignored nationally,
Right.
and often doesn't apply. And I also, going back again to this third-party risk assessment, you know, I'm in a ban-the-box state. So what does that mean? And why is that being delegated to the probation office to decide? I think the error, the judgment has to include only the conditions that the judge finds on a case-by-case, defendant-by-defendant basis apply. And probation will come back if circumstances change after a lengthy sentence. But as a national problem, I just think we're all complicit because there is such lengthy terms of imprisonment, usually front and center, that our clients are asking us to fight on that, and that a lot of this has gone by the wayside.
If I may, in the District of Connecticut, a Second Circuit decision came down. It was interpreted that it would be the judge at the time of sentencing who would impose the third-party notification. It caused a paradigm shift in how it was determined for each defendant to have this happen. But it has worked, to my understanding. I've been in contact with the deputy chief there, and she's indicated that it continues to work, that at the time of sentencing, if a third-party risk has been identified through the course of the pre-sentence investigation, that they will impose that condition. And if the person goes away to prison and comes back and that risk has been reduced, the probation officer can say to the judge, this is going to work. Or if the person comes back and the risk has increased, the probation office can go back and ask for a modification. And because it will create a more onerous set of conditions, there's usually a hearing. But it resolves itself. It seems to be working because that way it's being tailored for that particular individual.
Thank you. Ms. Mariano, you mentioned that you get notice of special conditions in the PSR. Is that a national practice, or is that just your district?
It is our district, and I think it may actually be throughout the Second Circuit, but I can't speak definitively. But there were some Second Circuit decisions, particularly in the sex offender area, that suggested that would be a good practice, because we brought it up on review, having not really litigated some of that in front of the district court. So now it's presented to us in the PSR. I don't know if it's done. It's certainly not done nationally. I don't know if it's circuit-wide, but I would suspect it is.
Any other questions here? I want to thank you all. It's very interesting. I really wasn't sure what to expect on this one, but you all made it very lively. So thank you very much for your comments, for coming here through the snow and into, actually it turns out it's quite beautiful outside, but wasn't
Thank you, Judge.
necessarily so. Thank you very much.
Thank you.